This is the Planning Podcast from Number 5 Chambers, and I'm Richard Kimblin. With me today are Odette Chalaby and Karls Copestake. Odette is a Planning and Environmental Barrister at Number 5 Chambers, being supervised in her pupillage with Nina Pindham. Karls Copestake is a planning consultant and senior planner at Knights LLP. Why are they gathered together today? There is a case which has proceeded very quickly through both the High Court and the Court of Appeal in the name of Mathew Richards, a young boy who is adversely affected, as far as his health is concerned, by the hydrogen sulfide emissions from a landfill site in Staffordshire near Newcastle under Lyme at a place called Silverdale. Odette is going to take us through the judgments in the High Court and the Court of Appeal and the consequences so far as the relationship between regulators and the courts is concerned in human rights cases. And Karl is going to take us on a journey back to September 2016 and the years preceding, when an appeal was decided in respect of a development outline proposal for 138 dwellings at a site close by to Walleys landfill, where the reason for refusal was concerned with odour. What's the relationship between planning and pollution control? So those are the topics. Let's hear what our guests have to say. So I'm here with Odette and Karl. Odette, good afternoon to you.
Afternoon, Richard.
And Karl, how are you?
Good afternoon, Richard. I'm well, thank you. Yourself?
Yeah, really good, really good. Looking forward to doing this. Let's just identify what you've both been doing in preparation for helping people through this case. Odette, which documents have you been looking at?
I've been mainly looking at the Court of Appeal decision in Richards and the Environment Agency, which is dated the 17th of January this year, and also the High Court decision. But that's what I've been focusing on.
Okay. And Karl, I think you've got a rather earlier document to help us with.
I do, Richard, yes. I've been revisiting the appeal decision by Inspector John Walcock into an outline application which was refused back in 2015, and that was an outline application for 138 dwellings in close proximity to Walleys Quarry.
So we've got the case of Mathew Richards, which is concerned with Walleys Quarry, Silverdale, and Karl, your appeal decision is also concerned with the same location, Silverdale.
Indeed, yes. The appeal site is located at the edge of Silverdale, yes.
Right. Well, I think it will become clear later why these two things have some links and interactions. But first of all, let's get stuck into the facts so far as the case in the High Court and the Court of Appeal are concerned. Odette, can you kick us off with what the essential points are which Mathew Richards was litigating?
Sure. So Mathew Richards is a 5.5-year-old boy, and he lives in Silverdale, just a few hundred metres from the Walleys Quarry landfill. And that landfill site has been operating under a permit issued by the Environment Agency for a number of years, and it's also the subject of a planning permission. And we find in the judgment that since about late 2020, there's been a serious increase of complaints made about hydrogen sulfide gas emissions from the landfill site. And that's meant to be really odorous, really affecting people's day-to-day quality of life, but also actually causing some quite serious health problems to the community, but in particular to Mathew, who was born prematurely and who has always had lung problems breathing. And the evidence of his doctors in the High Court was that they were concerned the emissions from that landfill, the hydrogen sulfide, was actually preventing his recovery, would lead to chronic obstructive pulmonary disease and reduce his life expectancy. So some quite serious problems being caused by that landfill site and increasing seriously from 2020. And Mathew brought a claim in the High Court alleging that there'd been a breach of his rights under the European Convention of Human Rights, in particular his Article 2 rights, so that's right to life, and Article 8, so his right to private and family life.
I think it came on quite quickly before the High Court, didn't it?
Yes.
And resulted in a very lengthy judgment.
Yeah, they wanted interim relief, but the court thought it would be better to just crack on with things as quickly as possible. So it did that instead. It was a lengthy judgment full of detail about the science, the technical information put before it, the number of experts. But what the court found was the slightly unusual conclusion was that it didn't actually find a breach of his Article 8 or Article 2 rights. But what it did do was make a declaration that the Environment Agency had to, within a particular timescale, comply with a number of recommendations given to it by Public Health England. So reach particular outcomes relating to the pollution levels. And it said that was absolutely necessary for the Environment Agency to act lawfully going forwards.
So that's a declaration, that's a statement by the court, not actually providing a remedy. That's what a declaration is. It's not saying that a decision has been quashed, but it was a rather unusual declaration which seemed to tell the Environment Agency what it had to do and by when.
That's right. And I think the Court of Appeal noted that it wasn't really a classic advisory declaration setting out the position, the legal position. It was more of a mandatory order requiring the Environment Agency to take certain steps by certain particular times. And that was quite unusual. And unsurprisingly, perhaps, the Environment Agency appealed it.
So, ground of appeal, look, you can't tell us to do things when we haven't been in breach. No breach, surely there's no remedy. Did the Environment Agency complain on any other grounds?
So it had two main grounds of appeal. And the first was sort of the judge erred in making the declaration of this kind in general, because that's simply not an area, the steps which the expert regulator needs to take. It's not an area for the court to be involved in at all. And then the second ground of appeal was that on the basis that there was no finding of any breach, any unlawful act, the Human Rights Act didn't allow the court to grant relief at all because there'd been no breach. So they're sort of interconnected grounds of appeal, but that's what they appealed on the basis of. And there was actually a cross appeal by Mathew Richards, who said that the judge essentially should have found a breach of Article 2 or Article 8.
What did the Environment Agency say about what it had been doing about the substance of the complaint? So was it the agency's case that nothing had been done, but nevertheless they weren't in breach, or were they saying we'd done what was proportionate in the circumstances?
Very much the latter, Richard. Since the issue had come before them, they were very much aware of the issue and were treating it seriously. And what they said was that they'd taken a number of actions since 2020. So trying to improve the capping and containment of the gas, trying to get the operator to improve the extraction infrastructure, increase monitoring to get better data, requiring a new plan, a new management and risk assessment plan. And it also crucially took advice from Public Health England, who made some strong recommendations. And what the Environment Agency said was that it was in the process of looking at those recommendations and potentially implementing them.
Okay. Well, I think that might be a good place just to firstly understand what the Court of Appeal did, what was the outcome, and then switch to Karl, and we'll see what was going on a few years earlier and how the planning inspectorate dealt with the interaction between the planning system and what the Environment Agency was doing. So, Odette, let us know what the court said overall. What happened to Mr. Justice Fordham's judgment?
Well, essentially, the court sided with the Environment Agency on almost the whole scope of its argument. So it started with dealing with the issue of the respective roles of the court and the regulator, and it essentially said that what Mr. Justice Fordham had done was prescribe precise outcomes that the Environment Agency had to achieve and a timescale for that. But those choice of means of how to achieve good levels of pollution is an area where there's a lot of latitude for an expert regulator like the EA, and there's a big margin of appreciation for the state. And that's clear from the whole lot of European Court of Human Rights case law that was before the court. And then it also found, so that was the first issue. The second issue was about the breach of Article 2 and Article 8. And it found that the court below definitely hadn't found a breach. And on that basis, it was inappropriate for it to grant relief in the form of a declaration because nothing unlawful had happened. So that was inappropriate. It then turned to the cross appeal, whether it should have found a breach of Article 2 or Article 8. And essentially, for similar reasons to the first issue, so focusing on the latitude of the state, the margin of appreciation, what was really interesting here was that it did find that those articles, the right to life, the right to family life, were engaged, found there was genuinely a real and immediate risk to Matthew's life, that his life expectancy would be reduced, and that there had been an impact on his community's day to day life, his private and family life, that reached a serious level of severity. So it found those things, but at the same time, it didn't find a breach because what it found was that the Environment Agency had taken the reasonable steps to remedy the problem through all those actions we talked about a minute ago. So it found that there was something serious going on, but it didn't find that the Environment Agency was actually to be found liable in the end.
That's fantastic, Odette, because that brings us right to Karls involvement. Because Karl, you were involved in, as frankly, so was I. You were involved in an appeal decision which you just outlined for us, which had, I think, that at its heart, rather similar topics. Do you want to help us with that?
Yes, indeed, Richard. The appeal decision is actually 5.5 years ago now, going back to 2016. And I gave evidence at an appeal, which was ultimately allowed. It was an outline application for 138 dwellings, which would be sited just 115 metres to the south of the active infilling area for Walleys Quarry. And the planning application had been refused by the council, and the main issue was whether the occupiers of this proposed development would be likely to experience unacceptable living conditions because of the odour emissions which were arising from Walleys Quarry. So, in addition to myself, we had an expert witness who gave odour evidence, and the inspector's conclusions were that the quarry itself was the subject of an environmental permit, odour management plan, and he concluded that there were extant dwellings which were closer to Walleys Quarry than our proposed dwellings, and that the odour management plan within it had the ability to deal with odour emissions. So the context for the appeal decision was very important. There were simply dwellings sited closer to Walleys Quarry than our proposed dwellings. And the inspector concluded that if odour did arise, that the odour management plan would kick in, identify it, and deal with the problem. And therefore, the living conditions of those extant residents were safeguarded. He also concluded that the framework provides that it should be assumed that the pollution control regime will operate effectively. And on that basis, that we could rely on the permanent odour management plan. And ergo, the proposed development would not be adversely affected if the existing residents were not affected. Occupiers of the proposed development would not have an unacceptable quality of life. And he went on to find no conflict with the framework.
So central to that, Karl, is the relationship between the planning and pollution control regimes
Indeed.
and the assumption or presumption
Yes.
that the pollution control regime environmental permit will be effective.
It should be effective, operate effectively. Exactly. Yeah. Yes. And the inspector was very explicit on that basis.
This is an appeal decision in 2016.
Yep.
Reference to some complaints made in 2013-14, but it does seem that the complaints were of a wholly different order by the time the matter got to the High Court. Is that your reading of it?
Yes, I think by the time the matter went to the High Court, there were far more complaints and far more continual complaints too. Perhaps the complaints previously were more periodic, and the odours were perhaps more periodic in terms of the spikes. It certainly didn't have perhaps the coverage, the press coverage that it now does.
But we do get to an interesting point, don't we? I mean, Odette might want to say something about this. We get to a point where she's just explained the relationship between the courts and the regulator. Karl, you've picked up the relationship between the planning system and the regulation of the landfill site. One's left with the question, to whom should Mathew, via his parents, complain?
I do think that's a really interesting question that arises out of all of this. I mean, what we see in these two cases is in the planning case, the inspector quite properly, according to what I think is now paragraph 188 of the new NPPF, quite properly saying that he needs to assume that regulatory regime, the EA, will be effective. and he needs to make his planning decision on that basis, on that assumption. So the inspector and the planning inspectorate in general not getting involved in the regulatory regime and sort of stepping back from it. But we also see a sort of similar, although from a different angle, approach by the Court of Appeal, who is really at pains to emphasise its own limited role in this sphere of regulating dangerous industrial activities, and really emphasising the latitude and margin of appreciation on the part of public authorities with licensing and supervisory functions. So I think that is really interesting. In both circumstances, it's sort of assumed at the heart of this whole system that the EA will operate effectively and that what it does will work. And the question does arise, as you say, of, well, who's regulating that? Who's regulating the regulator? And I guess the answer is government, but is it doing so effectively, and can it do it so effectively?
I suppose in a way we come back to Mr. Justice Fordham's declaration. His declaration was focused on the Environment Agency achieving certain outcomes. That's really what he was. You need to do this by this time. Whereas in fact, the Environment Agency's approach is to require the operator to do certain things. And that's the extent of their involvement. They require checking of gypsum board, etc., which might give rise to a source of sulfates, which might be reduced by the bacteria to give rise to hydrogen sulfide gas in the anaerobic conditions in the landfill. They're controlling the waste management operation, but they're not themselves subject to a requirement to meet a particular emission standard for hydrogen sulfide. And that's the difference between what the High Court was trying to fix the Environment Agency with and what the agency actually does.
Yes. I guess the agency would say that looking at its functions, I mean, it could suspend the permit or revoke the permit, but it didn't actually find that either of those would have any positive effect because the gas was already there and it needed to be contained or extracted. So there's a limit to what it could actually do, given that its power is relating to the permit and not to going on site and doing operations.
And what's happening on site, Karl? Is the scheme being built out?
It is, Richard. Yes, that the scheme has started. It's well underway, and indeed some of the new dwellings are now occupied.
Okay. Well, there's an interesting interaction between, in human rights terms, a very, very important case, and of course remembering that at the heart of it is a young individual that's got a serious condition. And on the other hand, an illustration of the way in which these various parts of the regulatory framework fit together, or perhaps some people might say don't. I found that to be enlightening, and I'm very grateful that you enlightened me. So thank you very much.
Richard.
Welcome. Thanks, Richard.
Have a great rest of your day. And as I say, listeners will be very, very grateful to you for that update and for Karl, your insight, bringing out from your archives what was going on in 2016, which has suddenly become of particular interest. Thank you very much, Karl.
You're welcome, Richard.
Bye now.
You take care. Bye-bye.
Bye.
That was the Planning Podcast from Number 5 Chambers. Thank you for listening. Do tune in next time. Until then, goodbye.